Hey guys, welcome back to my channel. For those of you who are new, my name is Morgan Thorne and I teach all about kink. I'm a kink educator both here on YouTube and in real life. I teach lots of classes, I have a couple of books, all kinds of fun stuff like that. So if you are interested in any of that stuff, I'll leave links in the description box and up in the cards. Today, we are going to talk about a case that just happened fairly recently here in Canada. For those of you who are unaware, I am Canadian. Yes, that's a very weird accent. I am Canadian. So we had a recent Supreme Court ruling about condoms and consent. And now, some of you may remember, if you've been here for a while, I did a video about stealthing. So I'll link that in whichever corner. I never point to the right one. So now I just point to both of them, but I'll include the video about stealthing there. So for those of you who aren't familiar with the term, let me explain what stealthing is. And it is basically agreeing to use a condom during sex, for penetrative sex, and then removing the condom when the other person is not aware of it. And so engaging in sex without a condom and without that person's consent to go without a condom. Now, the Supreme Court of Canada has just recently ruled that if a condom is required as a part of consent to the sexual act and it is not used, then that person could be guilty of sexual assault. So once again, if you agree to use a condom and you do not use the condom, in Canada, you can be charged and convicted of sexual assault, which is our sort of way that we phrase rape within the law. There's not a specific, I don't believe there's a specific charge of rape, but it's usually sexual assault. For the record, just in case it ain't clear, I am not a lawyer, okay? I'm not a lawyer. I teach kink. I teach about consent and things like that, but I have absolutely no legal expertise. So please just keep that in mind and don't take what I'm saying as gospel. This is what I've been able to learn from the news and reading the parts of the ruling from the Supreme Court that I was able to get through without kind of falling asleep. If anyone's ever tried to read legal rulings, they can get real boring real quick sometimes, even if it's something you're interested in. So the specific case that went to the Supreme Court was from 2017. That's when the complainant said that this particular act happened. So in 2017, the complainant agreed to sex with a gentleman named Ross Kirkpatrick, and we can name him because he has been found guilty in a court of law. This is all for public. Like his name is out there in the public, it's in the media. And that is the only reason that I'm naming him. The complainant in this case is not named, and that is generally the convention in Canada, that they will name the person that has been convicted. I'm not sure if they name the accused or not. It really depends on the news source you're looking at, but they generally will not name the complainant unless the complainant decides to come forward themselves. And in this case, they didn't. So we have 2017, a complainant who agreed to Mr. Kirkpatrick on the condition that he wore a condom, or to sex with Mr. Kirkpatrick on the condition that he wore a condom. Okay, they had sex, and the first time he wore a condom, everything was fine. The second time around, he did not wear a condom, and he did ejaculate inside of the complainant. So during the second sexual act, the complainant says that Mr. Kirkpatrick said, "Does this feel better?" And they agreed that it did feel better. Now, they thought he was talking about the sexual position that was being used, and it never occurred to them at that point in time that he was not wearing a condom, because if, it had, they would have stopped, because condom, if you want to have sex kind of thing. And so anyways, they continued, they completed the sexual act, he ejaculated inside of the complainant, and that is how they were able to realize that a condom had not been used. I'm sure we can all figure out how they figured that one out. And so Mr. Kirkpatrick was charged with sexual assault, and he tried to have the case dismissed, saying that the complainant consented to the sex. So, and here's, I'm sure it's probably very similar in most other countries. The way the judicial system works is that you go to your regular sort of court, like criminal court, and if you aren't happy with that, you can appeal, and it goes to the provincial court. And if you aren't happy with the outcome, either side, then you can appeal to the Supreme Court. And so that's basically what happened. So in 2018, the trial judge, so just the sort of regular criminal judge, dismissed the case and said that there wasn't enough evidence or whatever. I'm not exactly sure why the case was dismissed, but it was dismissed in 2018. And the complainant and the government decided to appeal this. So they appealed to the British Columbia Court of Appeal. This happened in British Columbia. And the BC Court of Appeal unanimously said that the trial judge had made a mistake, that there was, in fact, a case here, and it should go to trial. Now, Mr. Kirkpatrick, of course, decided to appeal this. This is how it works, right? You go back and forth. Whoever loses tends to appeal. So he appealed to the Supreme Court, and I'm sure was not thrilled with the result here. So the result is that the court was absolutely unanimous that sex, when somebody has agreed to sex with a condom, is not the same as agreeing to sex without a condom. And if you are told to wear a condom and you don't, then that can be grounds for sexual assault charges. So the court was unanimous in this. However, they were divided a little bit on the reasoning behind this. So the court was split 5-4 on the reasoning why sex in this case was a problem. So the 5 justices in the majority said that it was a matter of consent, that basically, and let me read you a quote here from Justice Sheila Martin, who was with the majority, so writing the majority opinion, said someone who consents to sex on the condition that their partner wear a condom does not consent to sex without a condom, right? So basically ignoring the condition that one has placed on the consent makes the sex non-consensual. So that was the majority's reasoning, that the sex was non-consensual because a condom was a condition of consent. A condom was not worn, therefore there is no consent. I will have to say, personally, I agree with this reasoning. If I give you a condition for my consent and it's not met, then do you really have my consent? No, you don't. However, there were 4 justices who did not agree with that necessarily, and they said that, yes, it was absolutely still wrong and still potentially sexual assault. However, the reasoning behind it was an issue of fraud rather than an issue of consent. And so basically, by, I guess, lying about condom use, it was defrauding the other person rather than ignoring their consent. And again, I'm not totally sold on that argument, but I haven't delved deeply into all of the legalese around it and all of the reasoning. But just on the surface, I do have to agree with the majority that a condition placed upon consent, if not met, negates the consent. So this will be interesting to see how things play out. I do believe there will be a new sexual assault trial for this complainant and accused. And a number of other sexual assault stealthing cases have been on hold here in Canada, waiting for the outcome of this particular case. So it's going to be interesting because now those will start going forward, and we will start to see what the outcome is, how this particular issue. Sorry, we have a problem here with people driving around with super loud, like aftermarket mufflers, and it's so annoying. Apparently, I live on a street where everyone likes to drag race. So annoying, especially when you're trying to film videos. Anyways, my bitching aside, it'll be very interesting to see what happens going forward with all of these cases now that they are able to sort of proceed. Like I said, they were put on hold pending the outcome of this particular case. So if we start to see a number of these cases and how they're decided in Canada, I will make a further update to this particular thing. And if I do see this type of case come up in the United States or other parts of the world, I'll definitely try to update as well. I am pretty sure that in most of the Scandinavian countries, at least, they are ahead of us, generally speaking, when it comes to these things, and they do consider that to be sexual assault, the whole stealthing thing. And I believe in the UK, it is also considered to be sexual assault. I'm not sure about anywhere else. And again, I'm just kind of going on what I've picked up from various articles. I live in Canada. I've never been to the UK. I've never been to the Scandinavian countries, so like Sweden and all of those. So if you are from those areas, let me know, what is the rule, what is the law in your area for about this kind of thing? Is it considered sexual assault, or is it fraud, or what is the deal here? So let me know. I'm curious to see what you have to say. As always, please keep the comment section civil. We don't all have to agree. That's fine. But if I see name calling, if I see gaslighting, if I see any of that kind of shit, I'm going to delete your comments so that other people can't see them. And chances are I'm just gonna like block you from my channel anyways. So don't bother. Have an adult conversation, have a civilized conversation, but let's not call people names. We can attack ideas without attacking people. All right, guys, thank you so much for checking out this video, and I will see you in the next one.